The following information, material, and content discussed and presented is covered under fair use. This is not intended to be, nor to be construed as, financial advice, tax advice, nor legal advice. If you need any applicable advice, please seek a licensed professional. To Be Fruitful Training Group assumes no liability for any actions you take using this information, as additional due diligence is required. All rights, titles, and actions or interests reserved ab initio without prejudice. Hey everyone, this is B with To Be Fruitful Training Group. All praises to the Most High. And today we're going to be covering a doctrine known as trust merger, or merger of titles in trust. And it's also known as the merger of the legal and equitable estates. All right. So we have out of Book 90, Corpus Juris Secundum on trusts, subsection 253. Construction as to passive trusts, merger of legal and equitable estates. Under a passive or dry trust, the whole legal and equitable estate is merged and vests immediately and directly in the beneficiary, and he or she is entitled to the actual possession and enjoyment of the property. The beneficiary may convey the estate and pass good title without the intervention of the trustee, or may call on the trustee to execute conveyances of the legal estate as he or she directs. In contrast, in an active trust, the legal and equitable titles to the trust property do not merge. And there are some applicable case sites for reference. And further, out of section 256, Book 90, we have merger of estates in trust property. Where the legal and equitable estates in trust property unite in the same person, there is a merger of estates and the trust is terminated, provided that no other interests intervene. The legal and equitable estates are coextensive, and the trust's intention is not defeated. When the legal and equitable estates and trust property unite in the same person, there is a merger of estates and the trust is terminated. It is essential that no other person's equitable interest intervene. Moreover, the legal and equitable estates must be coextensive, or at least the legal estate is more extensive or comprehensive than the equitable one. However, even where the legal and equitable titles are both vested in the same person, equity will, under certain conditions, refuse to recognize a merger, such as where that result would be contrary to the settler's intention and would destroy a valid trust. Trustee as beneficiary. There is a merger where the trustee is made the beneficiary of the same estate, unless the purposes of the trust have not yet been fully achieved, or there are distinct interests, as where the trustee is required to preserve the trust estate for remainder men. The remainder men is I think the closest thing would be considered it was a residuary beneficiary, although there are differences, but as far as understanding, that's a similar term that will help to give a better understanding. So, however, a merger does not occur where there are several beneficiaries and not all of them are trustees. Merger of life estate and remainder. Except with regard to spendthrift trusts, where the person having the life interest in a trust acquires the remainder interest, a merger results and the trust is terminated. Where the life tenant acquires the right in remainder as to part of the property, the merger and termination of trust are effective to a proportionate extent. However, a merger will not result in this manner, so long as the remainder is subject to possible defeasance. And here are some case sites for further review, if you so desire. And out of American Jurisprudence on trusts, subsection 90. The meeting of legal and equitable interests in the same person or persons. Merger. And a quote out of the Restatement on the Law of Trusts, the third, subsection 69. It is essential to the creation and existence of a valid express trust that there be and continue to be a separation in different persons of the legal and equitable interests in the same property. And if there is no separation of legal and equitable interests of a trust, that is, if the entire legal and equitable estates come together in the same person, the doctrine of merger may apply, and the trust is terminated. Thus, for example, a trust may be terminated based on merger of equitable and legal estates, where the beneficial ownership vests in or inures to the trustee, or where the legal interest or estate of the trust may be and is conveyed and transferred to the beneficiary. It is essential, in order to have a merger of the legal and equitable titles, rendering an attempted trust invalid, that the equitable interest of no other person than the holder of the legal title shall intervene, and that the legal and equitable estates be coextensive and commensurate. That is, the legal estate and the equitable estate are the same, or the legal estate is at least as extensive as the equitable one. The legal estate and the equitable estate are the same, so that merger applies where, for instance, by operation of law, the entire beneficial interest passes to the trustee, or the legal title passes to a sole beneficiary. Where the sole trustee has by subsequent events become the sole beneficiary of the trust, the trustee's legal interest and the beneficiary's equitable interest being of the same quality and duration, the legal and equitable interests merge, the trust terminates, and the trustee holds the property free from the trust. However, a trust was not terminated where the life income beneficiary had no authority or power over the real property of the trust. Although the life income beneficiary had broad discretion to direct sales, investments, and distribution of income, where the legal interests as to the real property were still held solely by the trustee, separate from any legal or equitable interests held by the life income beneficiary, and the beneficiary's children held the equitable remainder interest, which had not legally or equitably merged with their father's interests in the trust, so that the beneficiary's legal and equitable interests in the trust were not coextensive or commensurate, and did not encompass the whole trust interest. Observation: equity may refuse to recognize a merger, notwithstanding union of the legal and equitable estates in trust property in the same person, where such result would be contrary to the trustor's intention and would destroy a valid trust. Furthermore, there is authority to effect that the doctrine of merger does not apply to terminate a trust naming two or more trustees, the exclusive beneficiaries of the trust. And out of American Jurisprudence on trusts, subsection 262, time when interest becomes effective and duration and termination of interest. Merger of interests on termination. And again, quoting from the Restatement on the Law of Trusts, the third, subsection 69. Merger is an equitable doctrine. Under the doctrine of merger, a trust need not be continued where all equitable and legal interests in trust realty are held by the same person. Once a trust terminates, the legal title which was vested in the trustee then vests in the equitable title holder. The two titles merge, and the equitable title holder becomes the owner of a full fee interest. Under the merger doctrine, the beneficiary's equitable interest is terminated when the sole beneficiary is also the sole trustee. As in this situation, the legal and equitable titles merge and the trust is terminated. The doctrine of merger does not apply to property held in trust where there is more than one trustee and beneficiary, even if all the trustees are also the beneficiaries. And for further reading and research, we have those cases. And to further help define merger, we have Black's Law 2nd edition on merger. It defines it here as the fusion or absorption of one thing or right into another. Generally spoken of a case where one of the subjects is of less dignity or importance than the other. Here the less important ceases to have an independent existence. In real property law, it is a general principle of law that where a greater estate and a less coincide and meet in one and the same person without any intermediate estate, the less is immediately annihilated, or in the law phrase, is said to be merged, that is, sunk or drowned in the greater. Thus, if there be tenant for years, and the reversion in fee simple descends to or is purchased by him, the term of years is merged in the inheritance, and shall never exist any more. Of rights, this term, as applied to rights, is equivalent to eon fusio in Roman law, and indicates that where the qualities of debtor and creditor become united in the same individual, there arises a confusion of rights which extinguishes both qualities, whence also merger is often called extinguishment. Rights of action. In the law relating to the rights of action, when a person takes or acquires a remedy or security of a higher nature in legal estimation than the one which he already possesses for the same right, then his remedies in respect of the minor right or security merge in those attaching to the higher one. As where a claim is merged in the judgment recovered upon it. Lee County 510 CB 501. In criminal law, when a man commits a great crime which includes a lesser, or commits a felony which includes a tort against a private person, the latter is merged in the former. 1 East PC 411. Of corporations. A merger of corporations consists in the uniting of two or more corporations by the transfer of property of all to one of them, which continues in existence, the others being swallowed up or merged therein. In regard to the survivorship of one of the constituent corporations, it differs from a, quote, consolidation, wherein all the consolidating companies surrender their separate existence and become parts of a new corporation. So here we have a diagram showing the two different ways that a trust merger can occur. We have this particular diagram, which shows generally the most common, or the normal way, if you will, that a trust naturally terminates upon the merger of the legal and equitable estates. Alright, so starting with the top left, we have the settlor. The settlor passes the legal title and vests it upon the trustee. Then on the left side, or the bottom side of this, you have the equitable interest, or the equitable title, and that passes directly from the settlor to the sole beneficiary. So you have these two titles, right? So where does the trust merger occur? The trust merger occurs when the trustee vests the legal title in the sole beneficiary. So then, because the sole beneficiary has both the equitable interest, or the equitable estate, and the legal interest, or the legal title, the legal estate, the sole beneficiary has both, and since those interests unite in the sole beneficiary, the equitable interest is then merged and made subordinate to and incorporated into the legal title, and the sole beneficiary ultimately just becomes the legal owner of the property. Right? there's no more trust. The trust has been wound up and has been fulfilled, because that, all the purposes for the trust were satisfied, right? This is generally the normal way, and it happens upon just about any time that a trust is fulfilled or wound up and its purposes are met, right? The other time, and sometimes it's less common, is if both the legal and equitable title merge in the trustee, in the sole trustee, right? So you have here, the settlor passes legal title to the trustee again, and the settlor passes the equitable title to the sole beneficiary. So in that scenario, we're just going to presume, based on the circumstances with the diagram here, the sole beneficiary has already been granted the equitable interest in the res. So we're going off of that situation, right, with this diagram. So now the trustee maintains legal ownership, the legal title to the property, right? So that's already been vested with the settlor. Now where it actually occurs as far as merger is when the sole beneficiary grants all the equitable interest in the property to the trustee. Now when this occurs, the sole beneficiary has essentially either waived their rights or conveyed those interests to the trustee, right? There's a couple of different ways that this could happen. One, you have an agreement between the sole beneficiary and sole trustee. You can have an assignment of certain interests. Again, that would transfer those interests into the trustee, and the trustee would no longer hold the beneficial use or the enjoyment of the property for another, and would then be able to enjoy the use of the property, as well as the enjoyment of the legal title, to which he has already been vested by the settlor, right? So there are potentially a couple other scenarios where this can occur, but generally those types of things are the most common. So I hope this gives more light to the doctrine of trust merger and merger of titles in trust. If you are still, questionable on trust merger, I do have a class on Thursdays, and it is the exclusive equity live discussion. It used to be on YouTube, but I've just moved it over to Telegram for ease of use and convenience. So I will have a link in the description. Please join that. There's no cost. It's free. So I have that available. Now, mind you, there are certain types of remedies beyond this, like specific application, certain processes that are considered private that I can't always go over in the public side. And for that, I have my private classes on Friday. Please join. Like I said, I do go over specific applications of a lot of different types of doctrines, and a lot of other resources available with that as well. So if you need help setting up a trust, I do have services available for that. If you need a one-on-one call, and you basically like to figure out what the best course of action is, or how you'd like to implement equitable relief or remedies into your current situation, we can discuss that as well. I do have consultations available. I do charge by the hour, so $100 per hour. Other than that, please like, comment, subscribe. Please share with other people that you know. Again, if you have any particular doctrines or concepts as far as equitable processes that you'd like me to cover next, please put it in the comments. I'll take a look. Other than that, this is B with To Be Fruitful Training Group. All praises to the Most High, and we'll see you on the next one. Thank you.